Okay, our final case is Doyle and Peck versus Stewart and Lawhon.
Thank you, Your Honor. May it please the court. I am Bill Owen, appearing on behalf of the appellants Jimmie Doyle and Dana Peck, and I would like to reserve 4 minutes of my time for rebuttal. This case presents de novo two issues for this court's determination. First is whether you can brand or call someone a liar, indeed a blatant liar, and then duck a claim for defamation by claiming that this represents a pure expression of opinion. And secondly, it involves the question of whether or not in a defamation setting, the rule of single publication first action rule, single action rule, operates as claim preclusion, even where the defamation claim is not barred by statute of limitations or qualified or absolute privilege. In other words, where it fails in its proof, does the claim, subsidiary claim, and we'll say in this case is false light, invasion of privacy, does that claim also precluded by the failure in the defamation claim? We submit the latter case is not. Now, this case, like any other case, is factually intense, and you can't analyze it unless you look at the facts. And let me just spend a minute or a couple minutes to highlight those for you. Mrs. Doyle and Peck were members and officers of a Wakulla County Independent Voters Association. In the 2004 elections, the association put out a flyer or mailer which criticized the voting records of two incumbent commissioners. And neither of my clients were privy to the publication. They didn't organize the actual contents of the publication. They didn't even know what was in the publication until they received a mailer in the mail. The publication challenged or criticized the voting records of the two commissioners on two scores. First, it says they had voted to permit a private company to truck water out of Wakulla County. And secondly, they had repeatedly voted, I think the term time and time again, for explosive and destructive growth in Wakulla County. Well, the commissioners struck back. This is an election, and they came out with their own flyer. And what they said, those accusations are blatant lies, and we deny each of them. But they went one step further. They then proceeded to identify my clients as organizers of the association and referred to them as the source or directly alluded to them as the source of the untruthfulness contained in the association's flyer. After the dust settled, my clients sued in two counts: defamation, false light, invasion of privacy. The commissioners countered with a motion for summary judgment, went to the trial judge, Judge Sauls, and he bought both arguments that they presented. That is, that this was term liar is a pure expression of opinion, not actionable. And secondly, the single action rule does operate to claim preclude a claim for false light, invasion of privacy, even where there's been no bar of the defamation claim. Now, the first question is fairly easy, I think, and if you look at the Milkovich decision by Chief Justice Rehnquist, which is cited extensively in our brief, I think it decides that the term liar is an expression of a fact. It's not an expression of opinion. In other words, in that case, I refer to it as the Jones is a liar case. Judge Rehnquist was saying, well, obviously, if you say Jones is a liar, that's actionable. Can you avoid defamation by saying, in my opinion, Jones is a liar? And he wrestled with that and went back and forth and explained that you couldn't if it could be factually tested. In other words, there's some facts that are incorporated in that opinion. Yes, it can be. It is factually tested, or it can be factually tested, and it could lead to defamation. The court in that case rejected an opinion rule under the First Amendment to shelter defamation. Well, we're back to that case now. This case is simply flat out. They've labeled my clients a liar, and they said that's an opinion. You can't sue us on a defamation. We think that's gross error. Now, you don't need to run through the syllogistic reasoning of.
But now, wasn't the basis for the claim of blatant lies, wasn't that a reference to the original mailer? In other words, isn't the whole thrust there that what was said in the mailer amounted to lies? In other words, they're not saying we have other information on which to accuse these people.
No, you're correct. No other information. Did not go beyond the mailer. They said that the contents of the mailer are blatant lies, and we deny that voting record, and that's what's at issue. It doesn't go beyond that. You're correct. But you don't really need to get into a syllogistic type of reasoning process as Justice Rehnquist did. All you need to pick up is a dictionary. A lie is defined as a deliberate untruth, a deliberate falsehood. If it's a deliberate untruth or deliberate falsehood, you can factually measure that. And if someone says this desk is brown, you know, or that can be tested. I say no, that's a lie. That can be tested. That is it's not a deliberate falsehood if it's true, obviously. So the question is, did they vote to truck water out of the county? That can be factually tested. And if you label that as a deliberate untruth or a deliberate falsehood, and it's not a deliberate falsehood, then it's actionable. That's I think, simple logic, really. And so this is not a very complex question. Now, where it gets a little murky is their left-handed argument. That's their right-handed argument. Flat out, a lie is a label of a liar is an expression of opinion. I think that fails. Then they come back and say, well, if we say that an opinion is a deliberate lie, we can do that because that can't be proven factually tested. But really, it's the lie that you test. Is that a deliberate falsehood? If someone issues an opinion, for example, I guess you say, X says President Bush is a very competent leader, and Y hears that and say, Mr. X, that is a blatant lie. Now, is that actionable? Obviously, it's an opinion, but the lie the lie is saying that that's a deliberate falsehood. And it would be. If it's based on opinion, it is a falsehood. There's no question about it. So to label someone as a liar is no different than to label someone as a murderer or a criminal.
Now, in your example, are you saying that the person who said that is a blatant lie committed a tort?
I think they do, Your Honor, because I think it's subject to be. The question is that a truthful statement? In other words, you call something, that's a blatant lie. And the defense of that is my label as a lie is true. You can't sue me for defamation. Now, was the statement true? President Bush is a competent leader. Some people would say it's obviously not. Some people, but that's an opinion. That can't be factually tested, but to label that as a deliberate falsehood can be factually tested, and that's where the defamation comes in. If it's not any different than that is an apple, which it is, and then you say, well, that's a blatant lie. That can be tested. And to call someone a liar over a fact, if the fact is wrong, that's actionable. And to call someone a liar over an opinion is actionable too, because it can't be tested. You can't deliberately, an opinion does not generate a deliberate falsehood. It can't generate a deliberate falsehood. So to accuse someone of lying over an opinion, to me, creates an actionable tort. So that's the first question. And the second question is whether or not, under the single publication, single action rule, there's some kind of preclusion. Florida follows it. I think it goes back to the Fridovich decision, where they said if the core facts which give rise to defamation or barred by the statute of limitations or barred by a privilege, you can't create another cause of action and backdoor that tort. And that's true. I think that's true. But if you don't have a bar, if you just have a question whether one alternative cause of action, defamation, fails on proof, for example, if it was proven to be true, you can still have a claim for false light invasion of privacy. These are alternative causes of action, just like suing for trespass to the person and negligence.
All right, in this case, can you explain to us the difference between the theories, the different proof, and how you would prove one, how you would prove the other?
I can give you Bill Owen's version of that, Your Honor, but I'm not sure how that sits. To me, I think the raging controversy about false light invasion of privacy is where the accusation is not, it could be true, which sparks the defamation claim. It could be true, so defamation doesn't lie. You can still have a false light invasion of privacy where the publication presents a false picture or less than a full picture of the situation. And in our case, what they did is, let's assume that whatever the labels were true. My clients are presented in a picture of creating what's been labeled lies, and that's the false image. They didn't have anything to do with the creation of that. So the label of them as organizers and generators of the publication, which is labeled lie, true or false, that puts them in a false light because they didn't have anything to do with it. So I think that's the difference.
Isn't the only thing in the flyer is that the organizers of the association are Dana Peck, Executive Committee Chair, Ms. Jimmie Doyle, Secretary, and Palmer Carr, Treasurer. Isn't that the only thing that's said about that? That's
right. But then they go on and say the individuals have sparked or have, they certainly imply that the individuals created the untruthfulness contained in the flyer. If you read on past in the publication, I said they went one step further. This is not, we're not contending they libel the association. We're contending they libel the individuals as branding them of originating the untruthfulness that's contained in the flyer. So you're
talking about the sentence that said we would suggest that due to their untruthfulness, you ignore any comments or claims made by this group?
That's certainly part of it, Your Honor. That's certainly part of it. It designates these people as the genesis of the association, and then says that they are the ones that are untrue, and that leaves the brand that they are the ones that conjured up these untruthful representations, and that's where the defamation sets in.
It's not really clear, though, whether they're talking about the association or these particular people who have been mentioned as organizers.
I think that's a question of fact, Your Honor, and they can certainly argue that. So the pronoun there could mean the association. Instead of it, we use there. That's a question of fact. But we're on summary judgment here. The court bought their argument that liar can never be defamatory. You can label someone a liar, that's an expression of opinion. So that's not, I don't think that's the law. And the second argument is a very technical argument over the effect of the single publication, single action rule.
All right, sir. We'll preserve the balance of time.
I tried to stop before it got to the grinding part. May it please the court, I'm Billy Hughes. I'm with the law firm of Pennington, Moore, Wilkinson, Bell, and Dunbar. I represent the appellees, Maxie, Lawhon, and Mike Stewart in this case. The President Bush example that was just being talked about at this podium is this case. That is the real question. Let's be more precise about what exactly was said here. The Wakulla Independent Voters political advertisement said that Stewart and Lawhon were, and I quote, bad news for Wakulla County. It said that they had voted over and over again for willy-nilly, explosive, and destructive growth. And it used a fabricated photograph of a tanker truck with a very inflammatory message on the side as its political hook on the front of it for people to read it. Now, in response, the Stewart and Lawhon campaigns sent out a flyer that said that previous flyer contained blatant lies. It directed it to the specific publication, and it said that publication contained lies. Now, the question is whether that's actionable as default. That's defamation, excuse me. It's not defamation. It's not defamation for two reasons. I'll take them in reverse order. First, it's undisputably true that the picture was fabricated. The words on the picture were fabricated, and that no one was trucking water out of Wakulla County to Dade County or anywhere else. So we start out with the undisputed premise that the flyer was false on its face. The picture's false, the word's false, the innuendo's false. And the response flyer was absolutely correct when it said, those are lies. The second reason it's not actionable as defamation is that these were statements of pure opinion. Expressions of pure opinion is how the case law talks about them. We've cited you a bunch of cases that talk about the fact that an expression of pure opinion is not actionable as defamation. Smith, Fromm, Denby, a number of those cases, state and federal court. The question of whether a particular statement is an expression of pure opinion is a question of law for the court. So certainly the trial court was within its authority to make that determination here. That means when I come to y'all today, I get a de novo review, so you get to see if you agree. But certainly it was not a summary judgment entered on a disputed issue of fact. This is a question of law, and it's appropriate for summary judgment. Now, to make the determination of whether a particular statement is pure opinion, the court is supposed to look at the context of the statement. And that's what it did here. What is the context of the statement? We have a...
Well, you say there's no factual dispute about, for example, what the vote at the commission was?
No, Your Honor. What I was trying to convey is the question of whether the statement, that's a blatant lie, is a expression of opinion, is a question of law for the court there. Now, there could be questions of fact below that as to who said what and whose voting records did what. The distinction I would draw here is the characterization of those records. If you say the candidate voted for every growth plan that came in front of him, that's something you can test. If you say the candidate voted for willy-nilly explosive and destructive growth, you never get an answer to that, because what I consider to be explosive or destructive, you may not. What I consider to be willy-nilly, you may not. That's purely an opinion that you never can get to the bottom of. Even more demonstrative of that is if I say, you're bad news for the first DCA. Now, there's no way to answer that question. You certainly don't feel like you are. Somebody else may feel like you are. That's an expression of opinion, and you have every right to respond to that by saying, that's a lie. I'm not bad for the first DCA. There we have pure expressions of opinion on both sides. That's why the factual questions going below that don't matter to this summary judgment. That's what an election is for, and the election was held. As a matter of fact, one of these...
I thought one of your grounds was that there was no factual dispute, but that's not the case.
There is no material factual dispute, Your Honor, for purposes of summary judgment. I think there are always probably factual disputes lingering in the background below those decisional levels. Now, so it says that these gentlemen are bad news for Wakulla County. That's a personal attack and purely an opinion. It says that they voted for willy-nilly explosive and destructive growth. Because of those characterizations, that again is an opinion, although it attacks the voting records themselves, but it still is not something that you can test. And then finally, it just has an outright falsehood. Here's a truck throwing water being trucked out of the county when no such thing was happening. I submit to you that these candidates had every right in the world to look at that and say, wait a minute, voters, that's a lie. And they had the right to do that under the expression of pure opinion. Now, I'll concede to you, not all statements of opinion are protected. There's some things that don't get you there. Only expressions of pure opinion are protected. And for that, you have the publication includes the facts upon which it is based, or those facts are known or available to the reader as a member of the general public. In this case, we have both of those things, not just one or the other. it specifically addressed the Wakulla Independent Voters flyer. It said, look at that flyer, guys, that's where the lies are. It didn't just make some global exhortation of these people are liars or there's lies out there. It said, that flyer contains lies. Behind that, if what you're going to attack is the voting record, and that really seems to be what's going on here, and when you read the briefs, it's really couched as a factual attack on the voting records. Those voting records are available to the public. They can go see how these candidates and these incumbent commissioners voted, and then decide, the voters can decide, is that characterization correct? Were they really voting for destructive and willy-nilly growth? Are they really bad news? Or is the candidates correct? Are the candidates correct when they say, wait a minute, that's a lie. We're not that. The information is there. It's available. That makes this an expression of pure opinion, which is protected under the law of defamation.
What do you say about the false light claim?
False light claim is interesting. And I will tell you, I was trial counsel on it, as was Mr. Owen. I did not ask the trial judge to rule on the basis that false light is not an actionable theory in Florida. I did suggest to him that it was in doubt. I pointed out the Gannett opinion from this court, the Rapp opinion from, I think, the 4th District. I think the Supreme Court's going to tell us pretty quick whether we have that claim, whether such a claim exists in Florida or not. But in this case, the single action, single publication rule eliminates that issue. And so I told the trial court he did not need to make a policy decision as to whether that is an actionable claim because the claim is barred by the single action, single publication rule. Now, it would seem to me that the last word from this court would be the Gannett versus Anderson case. And that's the last thing I saw from here out of it.
All right, now in that case, the ruling was that you can't get around the statute of limitations by recasting a defamation claim as a false light claim.
That's exactly correct, Judge, and that's exactly what they've done here.
Is there a statutory bar? Is there?
No, what I meant by that, they have recast their defamation claim as a false light claim. We do not have a statute of limitations issue here, but I'll explain in just a moment. Under both the majority analysis and the concurring opinion analysis, which, by the way, was a single action, single publication rule analysis in the concurring opinion, this case falls both ways. Now, you're right. The precise issue in Gannett was which limitations period applied to a false light claim. But it's not just limited to limitations. If you look on page 8 of that opinion, it says, to the extent that false light invasion of privacy overlaps defamation, it must be treated the same way. Otherwise, the relatively short statute of limitations and other strict requirements in the law of defamation would have no effect at all.
But that's the rationale for applying the same statute of limitations.
But it expands beyond the statute, Your Honor, because it would have been very easy for the court to say, instead of saying the relatively short statute of limitations and other strict requirements, could have left all that other strict requirement out.
Mr. Hughes, moving beyond, those arguments about whether or not there should be a rule, I'd like for you to explain why it would be inappropriate to bring a defamation claim and a false light claim, both filed within the statute of limitations and both brought in the same complaint. Why are those inconsistent, or why should they be mutually exclusive? I don't really understand that. And
I'll address that within the context of this case. In this case, we have both causes of action based on the same publication. Okay? We have the same damages sought in both counts. Both are seeking reputational damages. The textbook claim for invasion of privacy, including false light invasion of privacy, is for emotional damages. And when you read those cases, they talk about that. The Gannett case discusses that as well. Here you have the same publication and the same exact damages. And what you're doing is recasting, with just retitling it to get around the...
Why couldn't you seek the same damages under two different theories? I don't understand that.
The problem is that when you start doing that, the invasion of privacy law subsumes the law of defamation. And over many, many years, defamation has developed defenses and limitations to protect free speech. And that's happened over a long period of time with a lot of thought that goes into it. And the danger here is that you take an invasion of privacy case, which is nothing more than a defamation case with another title on it, and you end run around all of those judicially and statutorily created defenses that we've come up with over the years to protect free speech. So the bottom line is a threat to free speech. And the analysis that you see from even
From
Dean
other
Prosser.
From other districts.
Yeah, and in the Gannett case has as well, and the Dean Prosser comments and the restatements too, tell you that's really where the danger is. And frankly, if the ruling in RAP is that there is no such cause of action, that's what I expect the rationale would be. I don't know if that's going to be the case, but that's what I would expect.
Okay.
Now, under the concurring opinion in Gannett and the other case law that we cited, Jovadia and Orlando Sports Stadium and some of those, the false light claim here would be barred by the single action, single publication rule, simply because they are based upon the same exact publication, and it's very clear they are when you read the second amended complaint, I think it is. For those reasons, trial court order should be affirmed.
All right, thank you, sir.
Thank you.
Mr. Owen, we'll hear from you again.
The mailer put out by the appellees did have this language. I think this is very important because this is a link that gets it across from a charge against the association to a charge against the individual, which I think is critical. It says, as the court pointed out, we would suggest that due to their untruthfulness, you ignore any comments or claims made by this group of individuals involved. And the individuals had previously been identified, including my client. So they are charged with the untruthfulness. Now, Mr. Hughes has made, I think, the argument that you can call something a lie when it's not a lie. And that's somehow an opinion. That's not an opinion. A lie, as I pointed out, is a deliberate falsehood. If someone says a statement, and let's say it's an opinion, and you said, sir, that is a deliberate falsehood, that's actionable because it can be proved that it's not a deliberate falsehood. An opinion is not a deliberate falsehood, but if you charge someone as a liar, you have branded them as someone uttering a deliberate falsehood. This is the charge here in this case. They've charged my clients as liars in a publication that goes to all the county. Now, is that actionable? And he said, no, you can't sue me because that's just an expression of opinion. And if the underlying statement had been a statement of facts, I guess you could sue me. But if it's an opinion, you can't sue me. Now, he mentions the little truck. The truck is a symbol. That's certainly an opinion. It's an opinion. It was a little pictorial. It reinforces the voting records. The first statement, they voted to truck water out of the county, a private company, that's a statement of fact. That can easily be tested, and to label that as a lie is actionable very clearly under any stretch of the imagination. The second statement where he said they voted willy-nilly for explosive and destructive growth, I think that's a statement of opinion. Maybe it has some facts in it, but it really is a statement of an opinion. To label that as a deliberate falsehood certainly is actionable when it's not a deliberate falsehood. It can't be a deliberate falsehood. It's an opinion. So unless, and you go back to Justice Rehnquist's analysis, he deals with all this. And he wouldn't have even gotten into the question if the term Jones is a liar is not actionable. Of course it's actionable. Anytime you call somebody a liar, at least where I come from, you better get ready to duck. That's a pretty big insult. And to do it publicly throughout the county, that's a terrible insult if it's not true. In this case, we think we're entitled to prove that it was not true. It was a deliberate falsehood that they did, that they made, and that can be tested. Now, one final thing, my time is out. Look at all those cases. The single publication, single action rule is simply a hangover, I guess, from defamation. Protects defamation, like a lesser included offense. Let's say murder, you got first-degree murder, second-degree murder, manslaughter. If the murder is barred by the statute of limitation, everything else goes away. But if it's not, if you don't have proof to a first-degree murder conviction, you can certainly prove second-degree or homicide. That's what we have here. There's no bar here. We're entitled to present the proof on both alternative causes of action. We're going to get one recovered. And a special interrogatory verdict will sort out which one prevails. Thank you.
All right, thank you. Thank you both. That completes our calendar for the morning. The court will be in recess.